Thank you, Chairman, for the introduction. Following Stephen is always a difficult act, since he steals all the good bits out of the story in the first place. But if I could just perhaps give you a perspective as a regulator and as the current chair of BEREC in relation to some of these developments at this point of time. I think the first thing to recognise that this is not a lightning flash from out of the blue, that actually this piece of this latest if you like, Telecoms Package is one of a suite that have been ongoing for a number of years. I mean, the original one going back to the 1990s of the open network provisions, if you like, formed the basis for this liberalisation, harmonisation of the market. And as we would see it, this largely builds on a lot of the infrastructure that has been put in place. And I think one of the positive things that came out of the review of the framework at the time, that there was a general belief, I think, that a lot of what was in place was fit for purpose, and therefore, in fact, the areas of focus, like the consumer empowerment in these ones, almost sprang from that. The process of the new package, I think everyone here would equally know, took considerably longer than was expected. There were significant disagreements, I think, between the Parliament, the Council and the Commission from time to time, but delighted to say that eventually on the 18th of December it was approved and is due for transposition by the 25th of May 2011. Obviously then, because of that transposition, a number of the provisions will not come into effect until the actual directives have been transposed. And in Ireland, this is the responsibility of the member state, which would be in this case the Department of Communications. In addition to the legislation itself, the member states have required to adopt the administrative procedures necessary to comply with the directives. Clearly, from our perspective, Comreg is already working on what these administrative changes are going to look like, and we will be providing some guidance over the next period of time, because we will expect the industry to be doing likewise and to be looking at the provisions and the changes that are flowing through from that. In our view, the provisions themselves are generally clear. They're not too complicated, and therefore, with the additional guidance that will be provided, we will expect all of the operators to be able to comply with the provisions from day one. That's post the transposition date, whatever that is. I suppose in terms of the actual specifics today, I want to concentrate, if I can, and try and find some space between the stuff that Stephen has done. On the first item that we see as very important coming out of the new regulations is clearly the one on consumer empowerment. I think a lot of this personally is somewhat overdue, but it is nevertheless very valuable and very important that it has been introduced. The existing provisions have been expanded and do provide greater granularity regarding the provisions of consumer contracts, for instance. The contract provisions now apply to the provision of electronic communication networks and services and are no longer restricted to consumers. Previously, the directive provided it and basically seemed to limit it mainly to consumers. On the contracts themselves, the right to exit, as Stephen has talked about already, is now in it. There will be a duration of contracts, maximum of 2 years. In addition, all operators must make contracts of 1 year maximum duration available, and contract provisions cannot be used to inhibit subscribers changing suppliers. So I suppose that's positive. There's a ceiling in relation to the duration of the contract, and there has to be a degree of choice open to consumers on that. Other areas where changes are provided for include, for instance, network neutrality. Again, I suppose if I was to ask everybody in the audience here what they mean by network neutrality, we probably would get 20 or 25 different answers. And it's certainly become quite confusing, I think, in the discussions in the European Parliament exactly what was meant by network neutrality from time to time. In the new regulation, NRAs will be able to specify minimum service quality for public networks and to avoid degradation of services and the hindering of slowing down of traffic over networks. However, given the significance of these provisions, the Commission will examine any proposed measures and may make comments or recommendation. Another important addition from the new Telecoms Package, which I'm pleased to note Ireland has had a leading part in, was in negotiations on the focus of services for peoples with disabilities. And I think all of us should take credit, one, for championing that, and B, for the actual work we've put in at a domestic level in terms of increasing the service to those of us in our community with disabilities. And I think ourselves, the department, those with disability, representing disability groups, have been working for some time in the Disability Forum, and that I think has provided a enhanced service for those with disabilities. The new regulation helps to address that going forward, but I think it's very notable that Ireland was one of the champions of that. Another change is related to the time of transfer of numbers, or porting, it is called for those of us in the trade. As you probably are aware, Ireland has a European leading porting time or transfer of your number from operator to operator of just under approximately 2 hours. In the new proposal, the current fixed line transfer, which can range anything up to 10 days, has to be reduced to a 1-day time limit. So again, I think that will be a challenge for the fixed line operators to be able to accommodate that. And there are a range of issues. I'm not trying to play it down, but I think the intention is that we would all consumers would be able to get a very slick and timely transfer of their numbers going forward. There are a range of other things which I'd intended to talk about, but Stephen has already done in terms of privacy, data protection, spamming, and all of these things, but I don't think we need to go into them again. I suppose the other significant element that came out of the debate as it was going on at the time is that the European Commission, at the beginning of the process, were very keen, I think, to have a European Telecoms Authority. And we in ERG at the time, and supported by the Council and others, I think have felt that this really was a step too far in the terms of trying to seek to be able to impose vetoes, not just on the market analysis side of it in terms of the market definition, but also to impose that in terms of remedies. And I suppose we're delighted to say that ultimately the sort of compromise that has emerged from this now basically doesn't extend that veto to the Commission in relation to remedies, but leaves it where we believe it naturally should be, which is with the national regulatory authorities who have the expertise and the knowledge about the specific market areas. As of now, the Commission will be required to consider notified remedies within 1 month of the notification. If it has serious doubts, a 3-month pause comes into play, and during the initial 8 weeks, BEREC, combines, if you like, the collected expertise of all of the 27 NRAs, is required to reach a decision on the appropriateness of the Commission's serious doubts and whether the notification in question should be amended, withdrawn, and where this is appropriate to make specific proposals. I think in that, and it's only a paragraph, it sort of really does change ERG in the BEREC context going forward. Because, I mean, for those who may have been around as long as myself, actually it started all off as IRG, which was the sort of loose club of members. It then moved into ERG with the 2002-03 framework, and then in 2009 we now have BEREC, where I think we have to take responsibility for a more coordinated approach going forward. And I think that obviously that puts the onus on us, but also the Commission then have to take the utmost account of the recommendations we make. So I think it's a shared responsibility as we would see it going forward, and one to be welcomed, but it does put an onus on us as regulators to provide a clear and, if you like, forward-looking perspective on what the regulation should be. And there's a range of other conditions that then go on to in terms of how BEREC may disagree with the Commission and whether the Commission then would withdraw. My personal experience is when the NRAs have reviewed the various market analysis and come up, as we have up to now, with an informal grouping, most of the areas where serious doubts have been extended, the NRA has generally removed the actual application itself. But I suppose going forward, the BEREC context puts an added responsibility because we have to have a 2/3 majority. We actually have to have a voting system involved on it, and it will put additional responsibility on us all. There have been some speculation that the Article 19 of the Framework Directive will allow the Commission to, if you like, veto individual remedies through the back door. I have to say that we don't, as you'd imagine, don't see it exactly the same way. The wording of the directive the article from our perspective makes clear that the Commission decision cannot relate to an individual notification of an NRA. A decision can only be issued after the recommendation has been enforced for at least 2 years, and proposed decisions be subject to a BEREC opinion and comitology. So whilst we have heard a lot of discussion around possible veto through the back door in Article 19, it's certainly not where we believe it to be. If I could briefly move on to spectrum, the process of moving forward towards the harmonisation of spectrum, as where feasible throughout the European community, is continued in the amended framework. I think this is only to be welcomed personally, and I think in terms of the embedding now of the RSPG, or the Radio Spectrum Policy Group, within the proposals, and the need to take the utmost account of that as well, I think is very valuable. The emphasis going forward will accept and define circumstances beyond the award of spectrum on a technology and service neutral basis. And I've no doubt Isolde will smile at that as one of the architects of the infamous WAPEX, as it was at the time. I think at the time that you're now in highlights anyway, Isolde. The practice has now been embedded in law, and the Commission will provide for trading as allowed for individual member states in other hands. I think the essence, as Stephen has said, is it probably didn't go as far as the Commission expected. The majority of decisions are still left with the member states, and yet it's one of the areas, I suppose, where at a European level the coordination of spectrum and the facility that that may bring is an important consideration going forward. Another area that has been introduced is the functional separation area, or as Stephen describes it, the remedy of last resort. And I think, you know, the only additional piece I'd add to Stephen's, my working presumption would be is that one would have had to see that the current remedies available in the toolbox had been utilised and had failed to actually work in practice before a functional separation case could be made, and that the Commission do reserve the rights in relation to functional separation. So I think it is one where you know, NRAs will have the nuclear deterrent going forward. I'm not quite clear myself that it can be reversed, and therefore, you know, as much discussion will take place between the Commission and the individual NRAs, and possibly BEREC in that mix. But I suppose it does now provide for functional separation. I suppose our concern as regulators throughout is that it's useful to get a tool, but it's of little use if the bar is set so high that in effect it's not actually usable. If I may move quickly then to the sort of the institutional change, and Stephen has touched on them, BEREC and the Office. You know, the Office does provide for the institutions. It does underpin the principle, in our view, of subsidiarity. It does leave to the NRAs, in effect, the areas where it should be left with in terms of the decision-making group. We see this BEREC and the Office as being an evolution of the European Regulators Group. Without crowing our own load, and I'm sure people here may have different views, I think the European Regulatory Group has come a long way since 2002, and we see BEREC as, in effect, moving that process further forward. The piece that hasn't been touched on too much, if I could just briefly touch on, is the Office part of it. As Stephen says, it's the European dimension to it. The Office is facilitated to employ up to 28 people. It's intended to be largely a mixture of experts. The location for the Office has not been yet determined. I think it's very clear from an NRA point of view, both from Comreg and from BEREC, we see the practicalities of this. You know, that Brussels should be the location for this Office. We've made that very clear. And I suppose it was heartening at the inaugural meeting of BEREC that Commissioner Kroes was very clear that she felt that that was also the right location to be going forward. We will be shortly publishing advertisements for the Office Manager and also for Administration and Finance Manager. As I say, salary is the only determinant. Location is as yet unknown, and the number of employees is somewhat unknown at this point in time. But I would have seen that by the end of this year, we could have as many as 5 or 6 members of the Office in place, rising over the next couple of years to a maximum of 28. But I suppose we as NRAs are very keen that that should be driven by what the activities are, and that those activities should determine the number of people rather than taking an arbitrary number of people and deciding we're going to have 28. That's what I've tried in those few sentences to try and find some areas that sort of illustrate the telecom package. I've tried not to try and cover too much of the space that Stephen has already covered. I suppose in Comreg and BEREC, we believe that the package does strike the right balance. It does address a range of consumer protection issues. It does nudge the process on the spectrum side forward a little. It does provide a deterrent of last resort. It does underpin the independence of regulation, which I think for all of us here, not just the regulators, the fact that regulators are able to make if you like, independent decisions and give a predictable outcome, if you like, to operators. And we may take that for granted here, but you can rest assured that isn't the case in every other market across the EU. And I think that is an important consideration going forward, that we very much welcome the underpinning of independence, because I think if companies are to invest, they really do need to know the context in which they're investing. I think from a BEREC perspective, we've moved very quickly. Within literally 10 days of the BEREC office regulation coming into place, we've had our inaugural meeting, we've elected all of the officials, myself included. We've also adopted our rules of procedure, and we will now have our second meeting of BEREC in Paris on the 25th and 26th of February. So I think from our perspective, we've moved very quickly on that front to put all the bits in place that we can. Clearly, some of the pieces on the transposition are still awaiting member states to put that into law. If I could just on the last piece say that apart from the BEREC piece, 2010 in my view will be an important year on a number of fronts, including the upcoming recommendation from the Commission on NGA deployments, which I think will be very important. There are also the issues on the revised USO, I think will be very important to regulators, the Commission, and primarily to consumers as well. And I think addressing this issue around network neutrality, just to mention a few of the issues, will be very, very important ones to get our teeth into in 2010. I think from a regulatory point of view, we're well positioned. I think the Commission and the Parliament recognise what NRAs have done, and I suppose it's up to us now to deliver on our part of it. Thank you for listening.
Thank you, John. So that was the
Thanks very much, Chairman. However little there was left to say after Stephen was up, after John, there's even less now, so you're probably wondering what I'm going to talk about. Thankfully, I'm not going to go back over the framework or directives, but what I've been asked to do is maybe think of 2 or 3 issues to just dip into in terms of the framework that are of interest to legal stroke industry, and that probably have generated a bit of debate since over the last couple of years. So you'll be presumably familiar with them, and it'll be interesting maybe at the end to hear what views other people have, because they're not matters that are entirely resolved. The 3 that I'm going to dip into are internet freedom. This is the restriction on, the ability or otherwise for ISPs to restrict access in certain circumstances, which is a hot topic. Data privacy and the mandatory notification, which again is quite an interesting topic, and we're all familiar with the media coverage over the last year of data security breaches, and that plays into how our particular industry handles it in light of these regulations, which is certainly different from other industries. And then finally, just touch on some comments around spectrum management and what the industry sees the good in that, as touched on already by John. Before just kicking into those, I suppose it's just a general comment from and as I say, when I say our perspective, I mean the legal stroke industry each time. I won't keep saying it, but that's the perspective we're coming from. From that point of view, the framework is, although a long time coming, very welcomed. I mean, generally across the board, there's a bit of something for everybody in it. From the point of view of consumers, the consumer protection, the long list of protections in the directive that must now go into contracts. Be a bit of work for people managing those contracts, but broadly speaking, that's not going to impact too greatly on most of the, well, certainly people in this room, and it's more geared towards the kind of the rogue traders who don't put in place the proper consumer protection. And in fact, in Ireland, in terms of the Consumer Protection Code that we already have, the Consumer Protection Act 2007, there's a lot of protection already there for consumers, so this isn't a very great departure from that in terms of compliance, but as obviously is in the interests of consumers. Obviously, the additional protection for users around privacy, the ability for ISPs to take on spam or spammers, and then the increased kind of regulation of cookies. Whereas up to now, cookies, as you know, if you're familiar with the word, they're basically tracking software put on your computer as you use websites. Before that was an opt-out scenario, or currently an opt-out scenario, and the proposal is that that would be opt-in. So there's a greater regulation of that type of activity, which is all positive. In terms of the ISPs, there is greater clarity in some of the areas, some of the points I'm going to cover around issues. And then certainly from the point of view, kind of the regulatory side of it and the regulator, I think, John has said it is all very positive. And the industry itself, obviously the regulated, would encourage that type of harmonisation across Europe and certainty with regard to the way they are regulated in Ireland. The three areas, so the first one, just to mention, as I say, they are kind of more legal, I suppose, than industry, but that's because of my own personal background and have a particular interest in them. But the first is this internet freedom provisions, which they're called. And this is the typical example used of what these provisions apply to is the file sharers in the P2P, and the whole you've heard the things about the talk about the 3 strikes and you're out. And this has a history in Ireland, a particular history in Ireland, which is maybe worth sharing with you. Some of you will be familiar with it. The record industry in Ireland, which are in this scenario that I'm going to explain, the rights owners. And believe me, I'm pro IP owners and rights holders and their ability to enforce rights. But they have had a history of being quite aggressive in terms of the way they enforce their rights in this country. And we've been involved, personally involved a few years ago on behalf of another industry defending royalties which they were imposing, which were basically a multiple of royalties that they charge in other European countries. So there's a bit of a history there. Then those in the industry know that they've taken a new target in the last couple of years, which is the telcos and the ISPs. And emanating in the litigation with Eircom, which came to trial but settled about 2 years ago, or maybe shorter, 18 months ago. And what arose, interestingly, out of that settlement that was reached between the record owners and Eircom, and the settlement was reached obviously in circumstances which we're all not familiar with, the heat of litigation, things were agreed. But what the record company took away from it was that this three strikes and you're out was the law in Ireland, which it clearly wasn't. And that was the basis upon which they wrote to all the ISPs, and we all have probably got letters from the telephone companies, and certainly as an advisor we've spoken to and advised companies who had got these letters. And it was particularly interesting in the context of the US players, where they had got this letter and they'd be on the phone and say, well, I mean, what is going on in Ireland? 3 strikes and you're out, is that the law? Because and in terms of any litigation, they'd fight it to the end, because they're so pro internet freedom. So what's good about this framework is that now it's clear that 3 strikes and you're out is not part of European law. And in terms of any ongoing litigation, current litigation with, for example, Eircom and UPC, the record companies and UPC are in litigation, this is all going to be highly relevant. And I think that is a very positive development in terms of the ISPs, because there was just too much being placed on ISPs in these circumstances where the 3 strikes and you're out system was in place, because they had to make calls to cut off and restrict access of their customers, and that is not a business that or an area that they really generally want to engage in, because they're acting as judge and jury. So that's a good development, I think, certainly from that perspective. And it's expressly stated that ISPs do not have to monitor or pursue alleged illegal file sharers. So one piece that is of interest. The second one that I was going to dip into was moving on a bit to data privacy and this idea now of mandatory notification. And this is if there's a security breach, ISPs or telcos and the e-commerce service providers are obliged to notify the relevant authority, which, depending on how the legislation plays out, is likely to be the Data Protection Commissioner, or it may be Comreg. Now, is that a good thing or a bad thing? I mean, people have different views about it. I personally having been involved, in advising companies who have encountered or had the unfortunate circumstance arise where they have lost data, I think that mandatory notification is not a good thing, because I think a judgment call has to be made And one of the issues I think at the moment is that when notification is made, that it's how that is used by the particular, in this case, Data Protection Commissioner, is important, and there's just a lack of certainty around what he will do with that information in terms of making it a public example and putting it in his report or treating it confidentially. So there is, I think, just that slight uncertainty at the moment as to what happens if you do notify a security breach. Now, interestingly, just in terms of the law, currently you are not obliged to notify a security breach to the regulator. In the DP's website, it suggests and recommends that you should, but it's clearly accepted. Certainly, the law in Ireland is that you don't have to do that. Now, you obviously run into other areas in terms of exposure to data subjects if you don't manage the situation. So, keeping in mind that you're not obliged to in law, this is a new development, and the reason why it's of particular interest, I think, to ISPs is because certainly the ones that I've mentioned it to or talked to, they say, well, why are we now being highlighted as a particular industry that has to do mandatory breach when no other one does? Now, in fairness, others may become subject to this mandatory obligation, but they're not at the moment, and this particular provision only applies to people in our industry. Finally, and just conscious of time, spectrum policy, I think, again, is a very topical area and one of great interest. And I think that there is a lot of positives out of the increased move towards harmonisation of spectrum policy. In particular, just as a personal comment, I think the spectrum trading aspects are to be welcomed. Clearly, spectrum trading encourages more efficient use of spectrum, more flexibility in its management, gives a true market value of it, allows people to sell underused spectrum, and particularly in light of current times where there is liberalisation of spectrum with the 900 and the 1800 and the digital dividend. I think it's important to get clarity around spectrum trading, particularly in Ireland, and would encourage, it's a matter for the legislator obviously, to introduce that as soon as possible. But would of course be very interested in what other people's views are in that particular area. So there are the 3 points I was going to dip into.
Thank you very much, John.